Hello, Sawadee Krap. I have already talked about the international arbitration in general in my last talk. So today I'll be focusing now more onto international arbitration on the cross-border settlement of disputes. So when you talk about cross-border settlement of dispute means where there is an involvement of two parties of two nations. Supposing like two parties, one belonging to USA, other party who belongs to England. So these two people, they have a business venture, and then in future if there is any problem on their dispute, they want to settle the dispute through arbitration. So in that case, they have the right to choose a neutral party. The third party means another country where the arbitration will take place in another country. So the dispute is between the citizen of USA and England, and they make an arbitration agreement that in case if there is any dispute, they will choose Thailand as a place, as a country to settle the dispute. So these are cross-border. They are not going to arbitrate their dispute in their respective countries, not in England or not in US, but they will choose Thailand as the third neutral party. So these are about cross-border dispute, international arbitration. So these are possible, and these are the advantage, because arbitration is sort of a private system of adjudication. Instead of going to the court, we are choosing our own parties to resolve our own matter in our own ways and means. So it is a private system of adjudication recognized by law, which will, because this will be well suited, and such kind of arrangement will be well suited, will be an advantage for resolving the cross-border disputes. So these are the advantage of international arbitration. And here I am particularly now trying to focus into international commercial arbitration. Arbitration is all related to business ventures and business. Usually party, they choose either one arbitrator system, or they will choose three arbitrators. So one arbitrator, there will be a sole arbitrator who will represent both the parties, who will hear both the parties and then pass an award. And other choice is that they will choose three, wherein the one party will choose one, other party will choose another one, and after they have chosen their respective arbitrators, these two arbitrators of the claimant and the respondent will choose the third arbitrator, who will be the presiding officer, or who will be the third arbitrator, or who will be the chairperson. So these are the models, either choosing one or three parties, one or three arbitrators. But in general, usually people choose three. People choose three arbitrators instead of one, because when you choose one, the disadvantage is that he or she may not be able to represent both the parties well, and there will be a problem in supposing like we have these personal feelings like your culture, your language, and all that thing. So that's where if you choose three, means that you are choosing your own, you are choosing your own preference, he's choosing his own preference, and there is the third arbitrator. So there will be a well representation of both the parties, and both parties will be represented well by their respective arbitrators, and these two arbitrators will be further guided by the presiding arbitrator. So usually people choose three model arbitration. That's the general trend. And actually then after they have chosen their arbitrators, then the other important thing is that how are they going to do the arbitration? How the arbitration will take place? Which rule will they adopt? Because now there are many legislative frameworks given option to us. Supposing like we have New York Convention, UNCITRAL model, this gives all the framework of how the arbitration should take place. So we can choose either these international instruments, conventions, or we can also choose some other national laws to be govern the ways and means of doing the arbitration. So That's why. Then other one is that people will the parties will also have an option to choose the rules of institution, the international institutional arbitration institution. In the world, there are many international arbitration institutions, and Thailand is one. And in Thailand, we are now trying to represent the Thai Arbitration Institution, which is one of the institutions which deals with arbitration. So people can choose our rules, and people can choose rules of Singapore, the USA, England, European Union, whatever. So they can choose which rule they want to adopt. If they don't want the institutional rules or international conventions, treaties, then they can also make their own rules. And this is one part of ways and means of choosing the rules of procedure for governing the arbitration procedure. Then after that, they can also have a choice to choose either the institution or on the ad hoc basis. The arbitration can be done, carried on, or managed by the institution. So if the people want to do arbitration through Thai Arbitration Institution, we will be there to monitor, to follow all the rules and regulations, how it will go on. And then if that people want to choose ad hoc basis, then in that case they can have other bodies or other neutral bodies who will take care of the arbitration. So these are two choices which the parties will have. So basically, I mean to say there is so much of flexibility how you want to do it. Then other one is that I have already told about the place. The place of arbitration is very important, where they want to choose place. And after that, they also can choose the language, in which language they want to carry on arbitration. Could be English, could be Thai, could be Spanish, anything, whichever language they want to choose. So the place of arbitration is very important, in the sense that if you want to choose the place of arbitration, means that you have to know the particular laws, rules and regulation of that particular place or a country. What sort of legal systems are there, judicial system, arbitration institutions, and all that we should know, because when you do arbitration in that particular country, there is a lot of influence especially from the judiciary, because if we have some problem, we have to go to the judiciary to seek interventions. And also, if we cannot appoint our own arbitrator, sometimes we also take help from the judiciary to appoint arbitrators for the parties. If the parties wants to do arbitration through the institution, then we can also request the institution to appoint arbitrator for us. So for that, choosing a place is very important. And once the arbitration is complete, once the award is passed, then the recognition of the award is also again done by the judiciary. So judicial interventions are there. So that's why choosing a place or a country is very, very important. And once the award has been passed by that particular country or place, then for enforcement, we have to see, because if that particular country is not a party or signatory to New York Convention, and that arbitration award will not be recognized in other parties, in other countries, other countries which are party to New York Convention. So for that also is very important. So if you don't select the right country or right place, so later on we might have many complications. In arbitration, one of the biggest advantage, which I've already talked before, is that the parties get substantial autonomy. They get autonomy, or they can autonomy or control over the arbitral process or the procedures, which are usually used for resolving the disputes. So party autonomy is very important, and we must, as a parties to the arbitration, we must be able to use our own rights to the best possible ways and means to resolve the matter in an amicable way. Because parties' control over the arbitration is very important, especially in international commercial arbitration. Because usually I talked about two parties from England and from USA. They want to do if they want to do arbitration, And usually there will be a tussle, there will be a difference by saying that a party from US might say that the arbitration should be done in my country because my business is based here. Then the other person who is from England might say that arbitration should be done in England, because each party will think that if you do arbitration in their own country, you get a lot of advantages. So ultimately, both parties are not going to agree to this, to have arbitration in their respective countries, because a person from USA might think that in England it's too expensive, and the judges in England may not be able to comprehend the system of US. So moreover, the England courts might have more support or some sort of bias thing on that particular person. And here this fear or unfairness or some inherent sort of doubt on that. And people, other person from England might think that if you do the arbitration US court might be more favored into his favor. So that's why when they have this tussle, then ultimately they think of coming to a neutral party. Because if you choose Thailand, then you know that Thailand court will have there will be no way of being unbiased or having attachment to one party or not. It is a neutral party. So they choose Thailand, and then for that they will agree. Okay, though we are from different countries having joint venture business, and in case if there is problem, we will do arbitration in Thailand, and taking advantage of a neutral party. And one of the most important thing is that having this the flexibility in the process, and also the flexibility in being able to choose the arbitrator and the country. Okay, you are choosing the arbitrator of your own choice. You are choosing a country which is more neutral, and then also you are choosing also a language in which we feel more comfortable. The language which will be fair for both the parties. So there are a lot of flexibilities in the arbitration, and that's where, since I am giving today a talk and discussion on the cross-border issues, so the essence of this is that two persons from two different countries are choosing a third country for arbitration seat, the seat of arbitration, and usually people do in that form, and there are a lot of advantages. So in that case, we should be very, very careful in choosing a place, because after that there are a lot of ramifications of choosing a place. You should choose the right place or the right country, and then after that, if you have chosen Thailand, if you do arbitration in Thailand, then if you choose the Thai arbitration institution, then you must follow our rules and regulation. And if you choose Thailand and TAI, then we will be at your advantage, because our institution has been doing arbitration for last 27 years. If there is problem between the parties, if you need to go to the court, then also set a timing and arrange all these things which we require, and also then sending the letters to the respective parties, following up, and at the end of the day, if there is problem in the arbitral award, parties can also approach to us to see whether it's as per the laws or rules or regulation. So for that, since we are now doing online arbitration, when you do online arbitration also, you can choose a place, because the arbitrators have the right, like competence. They have a right to choose the place for arbitration, and they also have a right whether there is arbitration or not, whether the arbitration agreement is valid or not, whether the contract agreement is valid or not. Since they have this authority, the arbitrators can always choose the place of arbitration. And this I want to touch only up to this topic today, and next time I'll just in my different series I'll talk on other aspects. I'll see you next time when I'm back on this series. Thank you.